There we go. And I'm back. Welcome back to the drama-free true crime destination. Welcome back to Bethea'S Byte Reloaded. I'm Ernest Bethea, the last outlaw. So good to have you here, and I thank you all for your patience over the last couple of weeks in trying to get back to this point. I appreciate you all. I'll give you all of my sincere thank yous at the end. Right now, we got a lot to get to. So, ladies and gentlemen, normally what is our missing persons report? This is an actual kidnapping report. So, take a look at the left side of your screen, and let me pull up to the photo real quick. There's four of them. All right. The man you see on all four of those pictures is Austin Bennett Tice. Austin Bennett Tice has been kidnapped from Damascus, Syria, on August 13th, 2012. Here's his stats. Born August 11th, 1981, out of Plano, Texas. He has brown hair, brown eyes. At the time of his disappearance, stood about 6 feet 2 inches tall, weighed 195 pounds, with a medium build. He is a freelance photojournalist. As far as scars, marks, and tattoos go, Austin has a scar below his left nipple and a metal plate in his jaw. Austin also has the following tattoos: an eagle on the left side of his back, a tribal band on his left arm from his shoulder to his mid bicep, and a barbed wire on his right arm. Now here's the details. Austin Bennett Tice was kidnapped in Damascus, Syria on August 13th, 2012. Austin was a freelance photojournalist and photographer for a variety of news organizations, including CBS, The Washington Post, and the McClatchy Company. Austin was kidnapped while reporting in Daraa, a Damascus suburb. Now, here is where I want you all to pay close attention to this. The United States government, yes, let me say that again, the United States government is offering a reward of up to $1 million for information leading directly to the safe location, recovery, and return of Austin Tice. $1 million reward. So, if you have any information at all concerning Austin Bennett Tice, please, whatever you do, do not hesitate. You are asked to call the FBI's 24-hour tip line at 1-800-CALL-FBI, 1-800-225-5324. You can also submit your tip anonymously. You can do this at tips.fbi.gov, or you can send it through email at findaustentice@fbi.gov. One last reminder again, the federal government is offering up to $1 million leading directly to the safe location, recovery, and return of Austin Bennett Tice. That's more than enough reason that if you see something, please say something so we can do something. Let's find Austin Tice. Let's bring him home safe. All right? Okay. Now, we are back. We're going to get back. We're going to get started on the docket. And the first thing we have is a verdict watch. All right, I guess you all know already about the New York City Subway Chokehold case. Well, there was a verdict earlier this week in that regard. We're gonna take you right to Court TV's coverage, led by anchor Ted. Age restricted, really? Hang on, guys. I'm gonna see what's going on with this.
Welcome back. Breaking news in the jury in New York.
Okay. Alright. I see what's happening here. So what I'm going to do is this. I'm going to duplicate that, and I'm going to copy the link so you can see it right here. So like I said, we're going to take you right to Court TV's coverage, anchored by Ted Rollins, and you will see this verdict for yourself. How does the jury find Daniel Penny in this case? Let's find out.
Welcome back. Breaking news in the jury in New York, deliberating the fate of Daniel Penny, has come to a verdict. Not guilty is their verdict. The Marine veteran who used a chokehold on a subway rider has been acquitted. This clears him of all criminal negligence here in Jordan Neely's death last year. A more serious manslaughter charge was dismissed last week after the jury was deadlocked on that count. The jury came back Friday, said we're deadlocked on the more serious manslaughter count. At that time, the prosecution wanted to dismiss the charge, which the judge agreed with. That allowed the same jury to come back today and start to deliberate count 2, criminally negligent homicide. On Friday, the defense didn't want that. They wanted a mistrial granted for both of these charges. The judge agreed with the prosecution, but guess who wins? The defense, because the jury comes back on the lesser. Criminally negligent homicide was what they were deliberating, and today they have come back with a not guilty verdict. There were no cameras allowed in this case. That is the breaking news at this hour. Joseph Tully watching along with us. And Joseph, one of those things where strategically the defense wanted the mistrial declared last week, but turned out that it worked out in their favor. This jury didn't take long today. Didn't even get to the lunch break, coming back not guilty on this count 2.
Yes, it's very surprising. This is why criminal defense world is so shocking and has so much adrenaline to it. Here you have a situation where the jury couldn't decide on the more serious charge. They were deadlocked. That means there were some people who wanted to vote guilty. So the prosecution and the judge took that off the table and said, okay, don't worry about deadlocking on the first charge. We'll just go to the lesser charge of criminal negligent homicide. And the jury came back not guilty unanimously on that, which is very surprising given that they were deadlocked on the more serious charge.
Yeah, it is hard to get you. Could it be frustration from the jurors as a whole? And we didn't know the split, which, if it was 11-1 or 10-2. But man, did you agree with the defense strategy to argue that there should be a mistrial granted on both charges once they came back deadlocked on the higher charge? One would think that that's the way to go, especially considering this, he is out on bail.
Certainly, yes. And the reason why you do that is because in criminal law, on the defense side especially, whenever you have something for sure, you grab it, even though it's not 100% of what you want. So here they had a situation where it was a deadlock. They wanted a mistrial. Judge, start everything over again. You take the for sure thing of a deadlock, which is a not conviction. Anytime the government doesn't get what it wants, that's a win for the defense. So here the judge and prosecutor tried to take that away from the defense, and it ended up backfiring on them, which is very surprising.
Daniel Penny accused of, he put Jordan Neely, this individual on the subway, into a chokehold, and the state says that this was manslaughter. The defense said that this was nothing of the sort, that he was coming to the aid of fellow passengers. Let's remind everybody of the body camera video. This was captured on video, but also the Penny was talked to immediately when this happened, and it was on body camera video from responding officers. Take a listen.
You got a pulse or no? You feel the pulse? You breathing, right?
Try it on the wrist. Try it on the wrist.
You got a pulse. You got a pulse. You breathing?
I feel like...
Nah, I feel the pulse. You got a pulse. You got a
Yo,
pulse.
man.
He put him on pulse.
Stay with me.
Keep breathing. Relax. Get off the train. How does he get off the train?
All right, that was they were tending to to Jordan Neely there on the train. Joseph, this is one of those cases that really divided the country. Did it get political, this prosecution, in your estimation? It sure did rile up a lot of folks on both sides.
Sure, I think it absolutely was political. We have different dynamics here. We have the person who died was black. The person who claimed self-defense was white. That always comes to the forefront. Not always, but frequently comes to the forefront in terms of the news, which I think is used as a tool of division, which we need to not have division. We need to have unity. Here, one thing that we should all be able to learn from is that this is also something that could have been avoided. This speaks to the mental health crisis in this country. Mr. Neely was not well. He had mental health problems, documented history, and it really is a horrific tragedy that it resulted in his death rather than just get treatment for mental health, which could have been provided under different circumstances.
Yeah, and a lot of people brought that up, that the defendant in this case was sort of not just Daniel Penny, but also, society in general, because it's not just the New York subways, it's mass transit in every major city. You have mentally ill people using mass transit as a place to find refuge and warmth, and also that interaction has created these tense scenarios, and it just is a part of that. What does the verdict say to you?
I think the verdict says that society is wanting safety. They're wanting, protection from people who are out there who could potentially be violent. And again, Mr. Neely, it was said that he was threatening the other passengers. And you quite clearly have to say that what happened is the jury putting protection and self-defense over issues like racial justice or racial division, where they're deciding, okay, let's drop the black and white thing. This is an issue of protection. We want protection. We want to be safe.
And there you have it. Daniel Penny acquitted of criminally negligent homicide, and the more serious manslaughter charge was dismissed earlier in deliberations because the jury deadlocked on that count. Both of those charges were felonies and carried the possibility of prison time. So, Daniel Penny, congratulations! You got acquitted. Now let's hope that your life will be one of peace. You'll never have to revisit this again. And now it's time for another installment of Diddy Do It? Just when the saga can get only as deep as it could get, it gets deeper. Music mogul Sean Jay-Z Carter has been formally named in a lawsuit that accuses him and fellow rapper Sean Diddy Combs of raping a 13-year-old at an award show after party in 2000. Combs was the only person identified by name when the lawsuit was initially filed in October in New York. Combs, who is in jail awaiting a federal trial on sex trafficking charges, has denied the allegations. Let's go to Court TV for more information.
But first, we want to share with you some brand new developments we are learning in the Sean Diddy Combs investigations and civil lawsuits. We know this is an ongoing case against him, and now we are learning that one of the civil complaints that's been brought against Diddy has been amended. It's been amended. And so you may recall us talking about this case previously, and a case about a 13-year-old allegedly being raped by Diddy, allegedly being assaulted and raped by another male celebrity who was previously not identified. Now, that celebrity has been identified. He's been identified as fellow hip-hop mogul Jay-Z. His name has been revealed. The allegation is that he and Diddy raped a 13-year-old girl at an after party in the year 2000 after the MTV Video Music Awards. Now, Jay-Z is denying these allegations. In a statement he posted to his X account, he denies the allegations and questions why this was done civilly, why this civil lawsuit was filed demanding money, and why a criminal complaint has not been made. He writes, quote, "My lawyer received a blackmail attempt called a demand letter from a lawyer named Tony Busby. What he had calculated was the nature of these allegations and the public scrutiny would make me want to settle. No, sir, it had the opposite effect. It made me want to expose you for the fraud you are in a very public fashion. So no, I will not give you one red penny." End quote. So that was what Jay-Z said publicly on his X account. In a statement to ABC News, that attorney, Mr. Busby, said, quote, "The pleading speaks for itself. This is a very serious matter that will be litigated in court." Now, this is the same lawsuit that was filed in October, accusing Diddy and accusing another celebrity of working in conjunction with Diddy to rape a 13-year-old not identified in the complaint, just named only as Jane Doe. And they also alleged in this suit that another female celebrity was there the whole time watching this happen. So basically, we've heard these allegations about Diddy, and we were wondering who these two other celebrities are. In the first suit, they were just named as Celebrity A, a male celebrity, and Celebrity B, a female. Female just said to be watching, but Celebrity B said to have been taking part in the assaultive behavior. So now that suit has been amended and Jay-Z's name has been filled in, his real name, Sean Carter. So now he's a defendant along with Diddy in this particular civil lawsuit. There's so much to discuss here. Let me bring in our law enforcement analyst this hour. She is a law enforcement expert. She's also a trial consultant. Sunny Slaughter on the program. Sunny, good morning to you. We talked about this. We talked about this when that suit was first filed. We were all wondering, who are these celebrities? Who is this man who's alleged to have raped this child, as Diddy is alleged to have raped this child? And who is this female celebrity who's alleged to have watched these rapes happen? What's your reaction, please, to this allegation being brought against Sean Carter and him not wanting to settle this?
Good morning, Julie. Here we go again. Here we go with this case and the unfolding of it. So when it comes to Sean Carter being named, you know, we've been hearing the rumblings and the ramblings that it could be him, that he could have something to do with this, and now the name is out. I have to agree with him. If this is a criminal case, criminal charges, let's see that happen. I am always, as a law enforcement expert, a litigation consultant, and someone that specializes in trafficking and sexual exploitation cases, concerned when we go to mediation regarding something that's criminal and not to the criminal litigation and for the investigation that is necessary in this case. Although it might be 24 years old, the allegations, we investigate cases that are 24 years old as law enforcement, and I think we need to see clear eyes and take down the temperature with the hype and get into the investigative material and start with Homeland Security Investigations, who has the expertise, who did the execution of the search warrant on Sean Puffy Combs stuff, and let's get into it that way as opposed to having mediation. These are criminal allegations, and we should not take them lightly, and particularly based on the age of the individual, and there could be others allegations.
Right, Sonny, and excellent points here, and let's keep taking it a step further. So you said this is a valid point, and I agree. I agree. I said it to my colleague, our senior producer on the show, Eric Goldson, when he said Jay-Z makes this point about why isn't this criminal? And I said, yeah, he's right. And I looked up the law. So the New York Child Victims Act, sometimes we hear it referred to as the CVA, a wonderful piece of legislation that opens up the window of the statute of limitations, right? Statutes of limitations, bar complaints that are outside of the window of time. And this extends them for child sexual abuse. And it does it in both civil court and in criminal court. And Sonny, you're familiar with this. So I'm doing the math here. This is alleged to have occurred in the year 2000. Okay, we're in 2024, and the statute of limitations is still open for a criminal case. According to what I'm seeing online, it's 28 years for felony offenses. Yeah. So if this rape did occur, there's to 4 more years that this can be filed. And this is just the filing. And you know that, Sonny, just got to get the filing in, and then the prosecution can commence. So I'm curious your thoughts on that, Sonny, as an investigator. There's been a personal choice by this now woman, then 13-year-old complainant, who has chosen to go the civil route with attorney Tony Busby to get justice instead of going to investigators that we know of. Tony Busby could have said something publicly in response to Jay-Z's comment that, well, she has reported it or something, but to our knowledge, there has been no report. What does that say to you when an alleged victim isn't choosing to go the criminal route?
So it could say multiple things, and one of those could be that maybe as a young person or as someone more mature, they did try that. And they had some type of negative encounter with law enforcement where they may not have been believed. Sometimes that does happen, and that could have made it impossible for this alleged victim to feel comforted by what law enforcement would and could do. However, with all of the spotlight now on the other case, now tying this into this case, they might feel like there's more leverage, and maybe they don't want to go to court and testify in a trial. However, I think it is the wrong thing to do at any place when we think that criminal charges against someone where there's an alleged victim that was a child, a minor at the time. I do not think that lawyers should take this tactic. I know they're defending their clients, but I do think that we need an investigation into this case. There is still the parents. We need to find out, where were the parents with this child? Who Who else did she tell? There's so many nuances that are not explained. I just don't think that we can say, okay, it's going to be a civil complaint, ignore the criminal charges. And like you said, we still have a 4-year window where charges could be filed, but we need to get to those first before we start talking about having a mediation.
Right. Excellent point, Sonny, as always. For anybody wondering who Tony Busby is, so Texas-based lawyer, we've got a quick clip of him. Let's take a look.
The biggest secret in the entertainment industry that really wasn't a secret at all has finally been revealed to the world. The wall of silence has now been broken, and victims are coming forward.
Okay, so he is the lawyer who has filed numerous claims. He is representing numerous victims. I can't even recall the number, but I know that, Sonny, you and I don't have enough fingers and toes to count all of the alleged victims that this guy is representing. And I'm saying alleged here, too, because we don't know. Look, we'll see what happens in civil court, however these cases are decided. They're merely accusations at this point against Sean Diddy Combs and now Sean Carter. Jay-Z. Yeah. So I want to dig into that story with you, Sonny. And full disclosure for everyone at home, we at Court TV just obtained a copy of this amended complaint. So I'm reading through this now. I have my computer open and I'm looking at it. So a couple questions right away when we think, how did this child even get into this party? And so, Sonny, what's alleged here is that she has someone drop her off because she wanted to go to the VMA Awards, has a friend drop her off near Radio City Music Hall in New York City. She wants to try to get into the VMAs. She said it was a bucket list thing for her, believed she could get in. Apparently, and again, this is all according to what Tony Busby set forth, but says that she started talking to limousine drivers who were parked in the area. And one of them who she spoke to apparently said that she fit what Diddy was looking for, that he liked younger girls. And this driver allegedly said that he had to take Diddy to the after party first, but told the plaintiff, come back to this exact location right after the VMAs and I'm going to pick you up and take you to the after party. And so that is what is alleged to have done, that this driver takes her there. She says she enters a large white residence, a gated U-shaped driveway, and claims that she might have been asked to sign a non-disclosure agreement. She's not sure, didn't get a copy of that. Sonny, I'm sure that'll become important later on as we analyze this. She says she sees many celebrities and there were waitresses circulating, carrying drinks on trays. She said she observed widespread drug use, including cocaine and marijuana use, took a drink that was reddish and yellow in color. She said it tasted like orange juice, cranberry juice, and something bitter. Says after that she felt woozy, felt the need to lie down. She looked for a place to rest, saw what appeared to be an empty bedroom, lays down on the bed. Soon after, she alleges that Diddy and Jay-Z, along with a female celebrity, enter the room. She automatically recognizes all three of them, says that one of them, Combs, said, are you ready to party? Had a crazed look at his eyes. She claims that Combs threw her toward a wall, causing her to fall. Says she got up, at which point he grabbed her, threw her again on the bed. At that point, she claims that Jay-Z removed her clothing as she grew more and more disoriented. The allegation is that Jay-Z raped her first. That is the allegation, that he vaginally raped her while Combs and this female celebrity watched. That's what's being alleged. Then the allegations go on to further state that after Jay-Z finished raping her, he stepped back toward a wall and that Sean Diddy Combs stepped in and vaginally raped her while Jay-Z and that female celebrity watched. I'm going to stop right there because I could keep going here, but that is the gist of it, that 2 rapes took place. That is what this complaint is alleging that Diddy and Jay-Z both raped her, and that this female celebrity watched it happen. Okay, Sonny, let's start from the beginning of this story. The beginning of the story starts with a limo driver. I'm thinking about this person, this adult who transported a child to a party, allegedly, Does that sound a little bit like some sex trafficking? I don't know, but boy, if I was a federal prosecutor, I'd be paying close attention to this, wouldn't you?
The allegation, you hit it on the head. So this is transportation, and sometimes people think transportation in trafficking cases means out of the state or over state lines or something. Transportation is any mode of transportation where you are moving an underage or individual that should not be moved to another location for sexual violence or trafficking, exploitation, any type of scheme. So first we have the limo driver, and I'm still talking about where were the parents, how did she get into this? And she never did make it into the concert that she wanted to make it in because that's not in there. So she immediately goes to this location. And then she's moving about with all of these celebrities. How is it that nobody in the room recognizes this very young? 13 is very young and very young in looking and age. We're thinking 2000. Okay, how is she there? How long is she there? And all of this activity that happens there, does she engage in alcohol and drugs? That is also another part and another point of criminal activity, serving alcohol and drugs to a minor. Another charge, allegations, once again, as we're saying this. And then how did she get to leave this location? I can't wait to look at this complaint myself and start unpacking it. But Julie, you started right where it needed to begin. These are allegations. They are very serious allegations. They are very heinous allegations, but they also need to be investigated because there are too many individuals, starting with the limo driver, starting with how she got to the location, and everyone in between that need to have the conversation, the investigation, the parents, and how she got there, how she got home, what happened, what did she say at school to her friends, counselors. Did she ever say anything to anyone else? Is there a therapist some point in time along the way? Who did she talk to? I want to know everything. I'm getting ready to get this complaint and unpack it myself too. And let's talk about it more because this is heinous.
Yes.
To say the least.
Yes, Sonny, agreed. These allegations are heinous.
Long enough to bring that up. It's been 24 years. The girl was 13 at the time. Why bring civil charges against him instead of just going for the gusto and bringing criminal charges? So that is definitely something to think about. As heinous as it is, think about it. 20 some odd years and you're bringing civil charges against him now. Diddy, I don't know. Diddy, I'm not too sure he's going to escape these charges, but Jay-Z is a whole different thing. I gotta listen to this a little bit more, and I've got to keep an eye and an ear out for more info. In the meantime, I'm going right back to Julie and Sonny Slaughter.
They are disgusting. They are reprehensible, and this is only a representation by one side. I can't emphasize enough how we're just being very clear in reporting this is what's being alleged. We're not a court of law, and we know it's being denied by both Diddy and Jay-Z. Both of these men have adamantly denied these claims. Sonny, you raised so many great questions. I'm reading further in this complaint about how this plaintiff, this 13-year-old child, is said to have got home. So it goes on to say that she did fight back, was able to stand up, grab her clothes and her shoes and run out of the bedroom. So the allegation is that after she was raped by these two men, allegedly, that she was able to grab her things, get out and hold her dress in front of her like a towel, cover up her body to an extent by holding her dress like a towel. As it says, she ran around the residence until she found the front door. It says, although there were other guests still at the party, no one appeared to take notice of the plaintiff's distress or attempt to help her, and that she put her clothes on after she got outside and left in the pitch dark. She ran until she reached a gas station. A female clerk saw her in distress, allowed her to use the phone. She called her dad, admitted that she lied about her whereabouts, asked him to pick her up. Dad picked her up shortly before dawn, and that it says she fell into a deep depression, suffers from PTSD and a seizure disorder alleged to have been caused by stress and trauma. Difficulty with relationships, difficulty functioning in society is what's being alleged here. Ooh, Sonny, you asked about the parents. You know, you said, where were the parents? And so here we have Dad potentially becoming a witness here because Dad sees her right after the fact, after this alleged trauma. What do you think about that?
The fact that there were so many people in this house, all of this went on. He has guards, you know, there would be guards, there would be limo drivers, there would be people, and she could make it out and run to the gas station. All of that is a lot. The father is absolutely a witness. And if you saw your child in that type of state, you mean to tell me you wouldn't take your child to the hospital? You wouldn't call the police? You wouldn't get more details? Where is the mother? Where are all of the other things that don't add up enough in this particular case? What is the relationship that she had with her parents? And if she calls her dad and he just comes out and does, a father that comes out and does nothing, that doesn't seek to find the answers, that is a lot to also unpack, and investigators absolutely need to talk to this witness, need to find the potential witness at the gas station. I know it's 24 years later, but she ran down the street. There were other things before she got to the gas station. What else do we know? Who else could have seen her? This is a lot, but once again, in these type of cases, let me say this, there are always a lot of allegations. They are always heinous. They are always irreprehensible, and they always need to be investigated. We need to have these allegations, as in every case, investigated, because if the limo driver said, according to the complaint, that this is the type of person Sean Diddy Combs likes, that means she is not the only one, allegedly, which means this is why this needs to be investigated. And if there are other young individuals or even older individuals, we need to have this investigated and not just fall on the allegations themselves. They are heinous. And this is what law enforcement does. No federal prosecutor wants to have this kind of information out there without a legal lens and the hands and the necessary tools that law enforcement have at their have access to investigate the case, whether it's 24 years, 30 years. We do this all the time, and I think it is a miscarriage of justice if this is not investigated before we start talking about money.
Right, Sonny. I love everything you said. I'm in complete agreement. I have so many more questions for you. I want to dig in with you on what investigators may do with this. Surely they're aware. They were aware of the existence of this complaint, weeks ago, whenever this was filed. I remember we talked about it in great detail, and now we have another major allegation being brought. And so we're going to talk more about, again, these allegations and Jay-Z's very strong response denying them. And again, reminder, Sean Diddy Combs has denied these allegations as well.
Let me try that again. I said they've denied the allegations, both Jay-Z and Diddy, but if the evidence is there, how can they refute it? We'll have to wait and see when we as this investigation continues. So stay tuned and keep your eyes peeled for another installment of Diddy Do It. Next up on our docket is another hot story that we've been talking about this past week. This is the case of the man who allegedly killed UnitedHealthcare CEO Brian Thompson. Police said the man had a gun, a mask, and writings tying him to the UnitedHealthcare CEO. Suspect in the killing of UnitedHealthcare CEO struggled with deputies and shouted while arriving for a court appearance in Pennsylvania a day after he was arrested at a McDonald's and charged with murder. Luigi Nicolas Mangione emerged from a patrol car, spun toward reporters, and shouted something partly unintelligible, yelling insult to the intelligence of the American people while deputies pushed him aside. Prosecutors were beginning to take steps to bring Mangione back to New York to face a murder charge, while new details emerged about his life and how he was captured. The 26-year-old Ivy League graduate from a prominent Maryland real estate family was charged with murder hours after he was arrested in the killing of Brian Thompson, who led the United States' largest medical insurance company. Let's go to a short report on that with Court TV's Michael Ayala.
To Pennsylvania, where a suspect has been arrested and charged in the death of UnitedHealthcare CEO Brian Thompson.
Joining us live now with all the latest is Court TV legal correspondent Kelly Craft. All right, Kelly, an extradition hearing was held a short time ago today. So please tell us what happened during that hearing.
Michael and Judge Ashley, Luigi Mangione, he has been charged with murder in the shooting death of the CEO of UnitedHealthcare, Brian Thompson. Just a short time ago, he had that extradition hearing in Pennsylvania. He is going to be fighting extradition to New York. He did not enter into that courthouse very quietly. In fact, when he was outside, he crashed against the wall as police were holding him, and he yelled, "It's completely out of touch," and an insult to the intelligence of the American people. So while he was in court, a defense attorney told the court that he would not be waiving extradition to New York, and that he does want a hearing. He has 14 days to challenge his detention. What you're taking a look at right now these are images from inside that McDonald's. So this was yesterday when an employee of McDonald's noticed him, contacted authorities, and then authorities began to question him, told him to take down his mask. When they asked him if he had been in New York recently, the officer reported that he became visibly nervous and he began shaking. So those are some images from yesterday, but of course the big news today is that he is not going to waive extradition to New York, so he has 14 days to file his petition and then have a hearing as to whether or not that will happen.
Not waiving extradition and still vocal, because I also understand there was a handwritten document that authorities found. What did that contain, Kelly?
Judge Ashley, it contained a lot of information, and possibly in regards to a motive in this case. It specifically mentions UnitedHealthcare, talking about the profits of UnitedHealthcare, how the company puts profits over people's lives. It also goes on to say, we have some excerpts we can put up for our viewers. It says, "To the feds, I'll keep this short because I do respect what you do for our country. To save you a lengthy investigation, I state plainly that I was not working working with anyone. He went on to say, I do apologize for any strife or traumas, but it had to be done, frankly. These parasites simply had it coming. Mangioni's family has also put out a statement. They said, our family is shocked and devastated by Luigi's arrest. Mangioni's family, they said that in a statement that was posted on social media. Now, another thing that we have been following and learning a lot more about is this alleged back pain that he has on one of his social media sites. You see his back possibly, that has appeared as if it has been fused together. One of his former roommates in Hawaii has come out and said that Mangioni suffered from extreme back pain that would impact every aspect of his life, from his romantic life to just daily activities that he would try to do, and that he had come to Hawaii to try to get healthy. So that's the latest that we have so far. Again, the big news, fighting extradition to New York.
All right, Kelly, thank you so much for getting us caught up on all the latest. Appreciate it as always. We'll let you go now and bring in our guest, still with us, former prosecutor Mary David. Mary, he's fighting extradition. I'm a little surprised by that. What grounds might he have, and what are the chances of success in terms of fighting extradition?
I am surprised as well that he's fighting extradition, particularly in light of the fact that he confessed to these crimes essentially in that handwritten manifesto, but this was clearly not a skilled assassin. He had his whole life ahead of him. I think it's very clear that there were mental health issues. I don't believe that fighting the extradition is going to really lead anywhere. I mean, it's pretty much an open and shut case that this is going to move forward.
It is going to move forward, but I wonder if he's doing it on purpose, because if he wants to continue making his statement and have a platform to do it, then I think he can do that by fighting every step of the way, forcing the government to prove every point, gives him a lot more exposure. I don't know that. I'm just wondering that, given that he even yelled out, Mary, you know, that doesn't always happen. Defendants usually at that point keep their mouths shut. He didn't. But what about this in his statements, that these parasites simply had it coming, the written manifesto of sorts, that can be used against him? Is that, along with the video of the shooter, can those things be sufficient to prove beyond a reasonable doubt that he is the shooter, the murderer in this case?
There is so much evidence here. The fact that he has a motive that has been unearthed by his roommate, him going off the grid essentially beforehand, wasn't really in touch with people, had a large sum of money on him and kept the weapon. It's possible that that leads me to think that he was maybe going to carry out other crimes in addition to the one that he had. And the thing that defendants, I think, don't realize, perpetrators, when they commit crimes, and he hasn't been convicted, I want to make sure I note, is the amount of technology that is available to law enforcement. There are so many surveillance images and so much that is, for good reason, not released to the public in terms of how law enforcement can access data, can access information that can point to a defendant's whereabouts, that I think will really be a strong case create a strong case against him.
Yeah, no question. And it was used in this case, but it's funny. Why was he caught? A McDonald's employee called in. So it's interesting. You go back to the very beginning. And I will say this, Judge, there is some mental health issue, or mental health issues in his past. But with the calculated nature of what we're hearing about how this crime took place, I'm not even sure that's available to the defense.
I don't know that it is, and it's so personal when you hear about the back fusion, the back pain, and those things. You just have to assume this was a personal planned attack.
And I will say this before we go to break. We'll go to break in a sec. Back pain?
Yes.
Serious back pain? Can affect the brain.
Yes.
It can absolutely affect the brain, so maybe there's an avenue there.
I wondered that. And as well, medications that people try to take to get any kind of relief because it's debilitating.
It sounds very serious.
Okay, the article goes on to say that that at the brief hearing, defense lawyer Thomas Dickey informed the court that Mangione will not waive extradition to New York, but instead wants a hearing on the issue. Mangione was denied bail after prosecutors raised concerns about public safety and a potential flight risk. Mangione was wearing an orange prison jumpsuit, mostly stared straight ahead at the hearing, occasionally consulting papers, rocking in his chair, or looking back at the gallery. At one point, he began to speak to respond to the court discussion, but was quieted by his lawyer. And now they made mention of the person who called called authorities on Mangione. The word is not. I can't confirm nor deny this as of yet, but that person has been terminated from McDonald's. But there's so much more. In fact, I can go ahead and drop in this this update if I can find it. Yeah, there's more. There's key details in the case, and it said writings have been found in Luigi Mangione's possession hinted at a hatred of corporate greed. Who else? Come on now, corporate greed. Who else has a doesn't have a disdain for corporate greed? And let's see. The man accused of killing the head of one of the biggest U.S. health insurance companies is fighting being sent to face charges in New York City, where the attack happened. 26-year-old Luigi Mangione is being held without bail, in Pennsylvania, where he was arrested at a McDonald's after a broad search following the December 4th ambush of UnitedHealthcare CEO Brian Thompson. During a hearing, Mangione's lawyers said he wouldn't agree to waive his right to an extradition hearing. Although it might delay the defendant being sent to New York to face murder and other charges, Blair County, Pennsylvania District Attorney Peter Weeks said Mangione's decision to fight extradition won't be a substantial barrier to it happening. New York City Governor Kathy Hochul said on social media that she would sign a request for a governor's warrant to ensure the suspect in the murder of Brian Thompson is held accountable in New York. So now I'm going to take you to the district attorney speaking on the shooting of the CEO.
Right now, let's get to your top story as we're learning brand new details about the suspect accused of murdering UnitedHealthcare CEO Brian Thompson. A first-degree murder charge could be soon added. Manhattan District Attorney Alvin Bragg spoke out Wednesday saying he's confident in getting Luigi Mangione, that is, to New York. He is that suspect. Bragg said that the 26-year-old could face additional charges beyond the second-degree murder charges that he is currently facing. And now, Mangione was arrested Monday in Altoona, Pennsylvania. He was in court in Pennsylvania on Tuesday, where his attorney indicated that he will be fighting extradition back to New York.
What are you doing? It's completely out of touch. And it's insult the intelligence of the American people and the lived experience.
Now, Mangione is being held without any bail in Pennsylvania, so we're wondering what is next for him. We have a very special guest I'm so honored to have on the program. Let me welcome now the district attorney in Blair County, Pennsylvania, where Luigi Mangione was picked up, where he's currently facing charges, Attorney Pete Weeks. Pete, good morning to you. And I just want to start by saying I have heard such wonderful things about you. I'm licensed in the Commonwealth of Pennsylvania, and you have a wonderful reputation in the community that you serve. And you've been there a long, long time, and we're so pleased to have you on this program to talk about this case. So if we could we start with the questions surrounding the extradition process? What is this looking like? What is the timeline, please? Would you kindly walk us through that?
Good morning, sure. So essentially, if someone is contesting extradition, our obligation is to prove that they are the individual that the requesting state is seeking. So we're in the process of working with the Commonwealth of Pennsylvania and the state of New York to secure what's called a governor's warrant. Once we secure that governor's warrant, we are going to file a request with the court to schedule a hearing as soon as possible. The court may schedule a hearing in the interim, but our burden is essentially to prove that the defendant is who New York is seeking. And if we establish that, which we're confident we'll be able to establish that, then the extradition can be completed and he will be sent to New York.
Pete, thank you for that. So for anybody wondering how the hearing goes, this isn't anything like a trial, is it? Or even anything like a preliminary hearing? Would you kind of explain the pieces of information you might introduce at the extradition hearing?
Certainly. We are not going to be involved in presenting any evidence relative to the crime. That is, for the state of New York. The extradition process, again, is simply identifying and confirming for our court that the defendant is the individual listed and sought in the arrest warrant issued by the Manhattan County District Attorney's Office and the New York City Police Department. So our burden is to establish his identity and that he is the person on that warrant. And we will do that through a variety of methods. And I expect to include his live scan fingerprints as well as other evidence that he is the individual who New York is seeking.
Extradition, all about the identification if someone is contesting it. Thank you for that, Pete. I want to take a look at the charges he's facing in your jurisdiction. Now, we put together them listed. I want to show them on the screen for everybody at home. So we've got forgery, tampering with records of identification, false ID to law enforcement, possessing instruments of a crime. Pete, what happens with this case in your jurisdiction? How will you proceed with these charges against Luigi Mangione?
Well, our priority is to cooperate with the Manhattan District Attorney's Office and New York City Police Department. We intend to focus our efforts right now on making the defendant available to them first for prosecution. Our charges will be held in abeyance pending his availability to us after New York is done prosecuting their case.
So essentially, the Pennsylvania case will follow along with the New York case, right? Seeing as these charges aren't as serious as what he's facing there. So will you kind of watch and wait and see, but he'll still have a detainer in PA, right?
Correct. That's our intention, is to proceed with our charges, but hold our charges, prioritizing the New York prosecution and assisting the authorities in New York in getting the defendant to them so they can begin that process.
Appreciate it, Pete. I want to ask you about where Luigi Mangione is being held, because something that really jumped out at me is that he's not being held in the Blair County, PA jail. He's being held in one of the Pennsylvania state prisons, SCI Huntington, which, as you know, is a rough place. You don't want to go there. Would you speak to why he's being held in the prison pending this hearing versus the jail?
That was just a logistical conversation that the Altoona Police Department, the Pennsylvania State Police, the authorities in New York, and myself had. We consulted with the warden from the Blair County Prison, as well as the Department of Corrections in Pennsylvania, and we agreed that that would be the ideal place to hold him until extradition can be completed.
Understood. Okay. Pete, I want to talk to you about the tip that came in from someone at a local McDonald's in Blair County. And I know, and this is hearing it from a very close colleague of mine who says how highly regarded you are in the county and how he really said this is largely to DA Weeks' credit. I think it's his opinion, saying that you've really fostered so much empowerment, cooperation, trustworthiness among members of the community with their local police partners and the members who serve in your office. And he said, really, I think that it's been largely the work you've done for many, many, many years where people feel empowered to see something, say something, and they trust they're going to be kept safe. Would you speak to what you thought when you heard about that tip coming in that perhaps this wanted fugitive was in your jurisdiction?
Well, first of all, I want to make it clear I'm privileged to work in Blair County and for the citizens of Blair County. Blair County has always been a strong law enforcement community. When I came here in 2007, the district attorney that I worked under and my supervisors in the office fostered that relationship with the community and with law enforcement. And I've attempted to continue that relationship. But we're privileged to have members of our community who work with the police, who trust the police. And again, if they see something and they understand that there's something criminal occurring or something that needs to be brought to the attention of the police, whether it be a crime in Blair County or in this case, someone who is a person of interest at that time in New York, they're going to call the police as they did, and they're going to let us know what's going on. I've always been proud of the way the community and our law enforcement work together, and you can see that when community and law enforcement work together, and law enforcement works with each other as they did in this case, that you achieve great results. And if not for the community speaking out and the responding patrol officers being vigilant and aware of what was going on, we may still be looking for this individual. So again, I'm privileged to be able to work in a community that has this level of cooperation.
Beautifully said. Blair County, Pennsylvania District Attorney Pete Weeks on the program this morning. Pete, thank you again for your time, for speaking about your case. And I know it's been a busy few days for you this week. When things settle down, we would love to have you come on the show as the legal analyst on one of our other cases, because I know you are one of those district attorneys who isn't afraid to get in the trenches and get your hands dirty. You've tried cases for many years, and I know everybody has a lot of respect for the fact that you still get in the courtroom, even though you're the top guy in the office. So we would love to have you back on the program someday to talk about another case that's not yours.
Okay, thank you, and thank you for having me.
Oh, my pleasure. Take good care.
District Attorney Peter Weeks, and this case is gonna take a lot of twists and turns before it's all said and done. So I'm gonna keep an eye out on this, including whatever more evidence we gather, what more we could know about Luigi Mangione, and so much more. So like I said, I'm gonna keep an eye out, and when I get these updates, you'll get it right here. Bethea'S Byte Reloaded, the drama-free true crime destination. Next up on the docket, a woman accused of disposing her husband's other wife's body was denied bond. Let me say that again, just in case you're like, what? A woman accused of disposing her husband's other wife's body was denied bond at an emotional hearing. All right. This is the defendant you can see right here before we can even get to the video, before we get to the coverage from Judge Ashley Wilcott and Michael Ayala. But first part of this article excuse me. A woman accused of helping her husband dispose of his other wife's body and cover up the victim's murder was denied bond at an emotional hearing. 20-year-old Kendall Mims is charged with accessory after the fact in the death of 20-year-old Jessica Barnes. Investigators say Jessica was murdered by 22-year-old Brandon Barnes, who was married to both women. Let me let you let that sink in real quick. This man is married to two women at once. The current wife, if I can call her that, and husband are working in concert to murder and cover up the other wife. Whew. Even that one's throwing me for a loop. Brandon, who is charged with malice murder, allegedly strangled Jessica to death in the home they shared with Mims and a third woman, 20-year-old Victoria Tippett, who faces charges of accessory after the fact as well. All right. Let me go ahead and take you to Michael Ayala and Judge Ashley Wilcott for more information on this case. Wow.
Turning now to South Carolina for an update on another case we are following closely here at Court TV.
A bond hearing got underway yesterday for suspect Kendall Mims. She's one of three people charged in the death of 20-year-old Jessica Barnes earlier this year.
And joining us now in studio with all the latest is our own Court TV crime and justice correspondent, Matt Johnson. Always great to be on with you, Matt. Get us up to speed on this case, please.
Judge Ashley, Michael, nice to see you both. A shocking case there out of South Carolina involving multiple wives, a secret love child, and a burned body. Brandon Barnes is accused of killing his wife Jessica in August of this year. Her remains were found weeks later. His co-defendants, Victoria Tippett and Kendall Mims, lived in the couple's pool house. Police say all three women had a sexual relationship with Brandon and that he called Mims his wife as well and fathered her baby. Yesterday, she was back in court.
There's three total co-defendants. They took the body down to a location near Lake Hartwell, and they disposed of the body by burning the body in a plastic tote. Ms. Mims served as a lookout during the burning of the body, and she also was just intimately involved in the process of getting rid of the body.
Judge, I don't know how we got here today. And I want you also to know that Kendall is heartbroken over the loss of Jessica. Even though it was a weird, strange dynamic, she loved her like a sister. Kendall did what she had to do to keep her baby alive, to keep herself alive, and to keep her grandfather alive.
There's a lot at stake. Kendall Mims facing these charges: accessory after the fact, obstruction of justice, and misprison of a felony, which is basically knowingly concealing information about a felony and not reporting it to police as a crime. Victoria Tippett is facing those same charges, while Brandon Barnes is also charged with murder. Michael?
All right. Now, Matt, what are we watching for during this particular bond hearing?
Fascinating hearing. Well, all three co-defendants have been denied bond until now, but now we have to watch what the judge is going to do. The judge now considering bond for Mims, who has a 9-month-old little baby. She was in court yesterday as her parents made the emotional plea for her release pending the trial. Take a listen.
My sweet daughter was also a victim who happened to survive this monster. His path of destruction. He was abused and tortured in every possible way, just trying to survive. She had to fight for not only her life, but her precious child's life.
Kendall, a quiet, naive spirit, introverted, and finding it hard to speak up for herself, became a victim of a narcissist sociopath who deceived her, came into our home and stole her away as he has done to so many others. Please have mercy and let our girl come home from this tragedy. Thank you.
A lot of arguments in court, and what you're also going to see is the prosecutor, otherwise known as the solicitor in the state of South Carolina, opposes bond, pointing out that after the murder, the co-defendants allegedly fled to Colorado. It's a very emotional hearing at the center of this love triangle murder case, and the judge's ruling also very interesting in the end.
There is one thing I can agree with that that defense attorney, and that is this is a strange set of circumstances involved in this case. Strange set of circumstances. In fact, Mims' defense attorney, Catherine Wise, pleaded with the judge to release her client on bond, describing her as a, quote, sweet, gentle, kind young lady who fell victim to Brandon Barnes, as did so many other women. Wise said that Mims suffered severe abuse at Brandon's hands, including strangulation that has left her experiencing stroke-like symptoms. Records reviewed by Court TV revealed that Mims and Brandon were issued a marriage license on July 31st, 2023. Brandon and Jessica were issued a marriage license on January 8th, 2024. But there is no record of the marriage to Mims being annulled. Pendleton Police Chief Doyle Burdett told Court TV that when Brandon met Jessica, he lied and told her that both women were his sisters to convince her to move in. Mims is the mother to a 9-month-old baby who has been in the care of Mims' 81-year-old grandfather since her arrest. At her bond hearing, her grandfather asked the judge to release her as Mims' father emphasized how badly she is needed to help raise her infant. The judge ultimately denied Mims' bid for bond, finding she remains a danger to the community. He said the issue could be revisited in 90 days after attorneys in the case receive more evidence and reports. Guys, I am trying to make heads and tails out of this, and right now, I can't. You got a guy married to one woman. You got a guy married to another woman, but didn't annul the first marriage. And now wife number 2 is now deceased. This guy, his current wife, and another woman all being charged in the death of wife number 2. Maybe I'm in a fog for this particular case. Maybe I'm in a fog. I will look for updates. I will look for anything else I can find on it, and as I find it, maybe the fog will lift. And when it does, as always, I will bring that information to you. Next, we have the sentencing. we have the sentencing in what was called the Judge Jumper Attempted Murder Trial, Nevada versus Deobra Redden. During his sentence, he told the court, "I'm not an evil guy." That's before the judge sentenced him for the attempted murder of a Las Vegas judge. So we're about to go into the courtroom and find out what is the fate of Deobra Redden.
In my view, you committed separate crimes, and that results in separate sentences. So it's not going to run concurrent to what she has previously issued as far as a sentence. All right. With respect to this sentence, first of all, there will be a $25 administrative assessment fee, a $3 DNA administrative fee, and Mr. Arnold, were you appointed or were you retained on
No, I actually did this case pro bono, Your Honor.
Okay. There will not be any DNA testing fee because, frankly, given your history, it's already been taken. Your actions on that day, you know, it was not just retaliation for an attack upon Judge Holtis. It was also an attack on the judiciary. And I'm mindful of that. And while there is no question that you've got some mental illness issues, which is why you pled guilty but mentally ill, but there was no doubt by these doctors that you knew the difference between right and wrong when you did what you did. So this is what I'm going to do with respect to the sentence. Okay, with respect to count one, sir, I'm going to do this. The minimum term that you would serve would be 8 years, and the maximum term will be 20 years. Plus, there will be a consecutive potential maximum term of 8 years to 20 years. So with respect to count one, the minimum term that you will be serving combined would be 16 years, and the maximum will be 40 years. With respect to count two, the minimum term that you will serve will be 4 years, and the maximum term will be 10 years. With respect to the consecutive enhancement, the age enhancement, the minimum that you will serve will be 4 years, and the maximum will be 10 years. So with respect to count two, the minimum term combined will be 8 years, and the maximum will be 20 years. The term that I impose with respect to count two will run concurrent to count one. With respect to count three, the minimum term that you will serve will be 2 years. The maximum term will be 5 years. That term will run consecutive to count one. With respect to count four, the minimum term that you will serve will be 4 years, and the maximum term will be 10 years. That also will run consecutive to counts 3 and counts 1. With respect to counts, well, wait a minute, yeah, okay. With respect to counts 6 and 7, sir, the minimum term in both of those counts will be 4 years. The maximum term will be 10 years. However, those will run concurrent to each other, right? So I'm not following what your attorney has suggested. I am following what the state has suggested. Did I catch them all?
I believe you skipped 5.
With 5? Correct. Sorry about that. Okay. The sentence with respect to count 5 will be a minimum term of 2 years, and the maximum will be 5 years. That will run consecutive to count 4.
And then counts 6 and 7 are concurrent to each other, concurrent to...
And consecutive to, well, wait a minute. That was, count 6 was with respect to Officer Brandon, right?
Officer Boo. You're on
Officer Boo. That will run consecutive to counts, the other counts. See if I can...
Yes, ma'am.
Did you get all those?
So with respect to count 6, it's to run consecutive to counts 1, 2, 3, 4, and 5.
Right.
And then as far as count 7, it's to run concurrent to count 6.
Correct.
Thank you.
Could you give me the aggregate, please? When you get a chance to. Do you need a calculator?
Yes.
You show 26 to 65.
I'm going to verify. Well, that does sound about right, but let's verify.
And Your Honor, as to the restitution?
There will also be restitution to the victim.
Thank you, Judge.
I still keep coming up with 36 on the top. Maybe it's 22. So here on count 1.
Counts 1 and 2, that's 16.
Yes.
That's 8. And 8 goes into 16.
Yeah, so here I have and then we have the added 8 over 20. The average is 16, 40. Right. And then here you have, it's going to run consecutive, so you said average.
Well, actually, this will run
concurrent. Oh, concurrent. I'm sorry, that's why.
Okay.
Okay, so 26.
Yeah, count 2 will run concurrent to count 1.
So 26 on the bottom, and on the top, you have 40. What's your concurrent? How many months did you have on the bottom? 20?
We had 26 years to 65 years aggregate.
65. That looks about right.
Okay. And there will also be restitution to the victim, payable to the victim in the amount of $61,318.41, and that is CCMSI?
Yes, Your Honor.
And what does that stand for?
I don't know. I apologize, Your Honor.
Okay, could you do me a favor
I can
and
look
let me know what that is? Because we need to put that in the judgment of conviction. And we need to give this gentleman credit for time served.
16 days.
60 days?
16.
16 days. Okay.
Thank you.
Thank you, Judge.
Okay, thank you.
So if you're like that person in the gallery asking at the very end, how long did he get? Deobra Redden has been sentenced to spend between 26 at minimum, 65 years maximum in prison. On the second day of his trial, 31-year-old Redden pleaded guilty but mentally ill to all the charges in a second amended indictment, which Judge Susan H. Johnson accepted. The state was willing to stipulate to allow him to withdraw his prior pleas of guilty on counts 2 through 7. At his sentencing, Redden addressed the court directly and questioned why prosecutors requested the maximum possible sentence. I don't understand why the state is really going after my character, Redden told the judge at his sentencing. I'm not a bad person. I'm not an evil person. Redden further told the judge he didn't want to be known as a person with mental illness because those people get attacked. Redden was initially facing 7 charges but pleaded guilty to all but 1 charge ahead of jury selection on September 3rd. He had pleaded not guilty by reason of insanity to attempted murder of a victim 60 years of age or older. Redden had not reached any agreement with prosecutors before pleading guilty. In January, video of the incident that reportedly left Judge Mary Kay Holtis with bruising went viral online. During the hearing, Judge Holtis was sentencing Redden for an attempted battery charge. As she was preparing to hand down a sentence, Redden was seen jumping over the bench toward her. According to that arrest report, Judge Holtis said Redden knocked her out of her chair and slammed her head against the wall before ripping some of her hair out. The report also stated that 2 marshals were notified of a panic alarm but were dispatched to the wrong courtroom. Redden's defense team and family says he was diagnosed with paranoid schizophrenia. Redden retained criminal defense attorney Carl Arnold, who was also representing Dwayne Keefe D. Davis in the Tupac murder case. Redden has a long criminal history, including 3 felony convictions, and that's according to Scripps News Las Vegas. Once again, Deobra Redden sentenced to 26 to 65 years in prison for attacking the attempted murder of a judge. Hope it was worth it. Now, the next story on the docket is in regard to the kidnapper who allegedly faked his own death and fled the country. This gentleman is taking the risk that a few other defendants have. He's going to represent himself at trial. I won't go to the video with Judge Ashley and Michael Ayala, but I will go as far as this article. A Wisconsin man who faked his own drowning and left his wife and 3 children for Eastern Europe willingly returned to the United States after 4 months and was charged with obstructing an intense lake search for his body. The criminal complaint charging Ryan Borgward with misdemeanor obstruction offers a detailed account of how the 45-year-old pulled off his disappearance, including how he struggled to emerge from the water, almost didn't make it through customs on his way overseas, and was living in the country of Georgia when he realized he had left too many clues behind. Police said Borgward turned himself into authorities at the Green Lake County Sheriff's Office in Wisconsin. A judge entered a not guilty plea on his behalf during a brief court hearing. He was released on $500 bail, although he would only have to pay that amount if he misses a future court date. Borgward told Judge Mark Slate that he would represent himself going forward since he has only $20 in his wallet. The judge advised he could get a court-appointed lawyer, but didn't name one for him. It's unclear what Borgward plans to do now. His parents were in court, but he was let out by bailiffs after the proceeding ended without speaking to them. Bailiffs escorted the couple out through a rear door to avoid waiting reporters. Borgward was reported missing on August 12th, according to a criminal complaint. Borgward told investigators that he had been researching how to disappear, studying lake depths, and how deep a body has to sink so it wouldn't resurface. He attended church with his family on the morning of August 11th and then put his plan into motion that night, driving 50 miles from his home in Watertown to Green Lake. Sheriff Mark Podol said Borgward told investigators he picked Green Lake because it's the deepest lake in Wisconsin. He paddled his kayak to the middle of the lake, inflated a raft he brought with him, overturned the kayak, and paddled back to shore in the raft, dumping his cell phone and a tackle box with other identification in the lake on the way, according to the complaint. Borgward said he had to make this believable so that everyone, including law enforcement, would think he drowned in the lake, the complaint said. He told investigators he struggled to get out of the lake, sinking into waist-deep muck, worried that police would find his muddy footprints. He tried to wash them off the road before retrieving an electric bike he had stashed nearby. He traveled 70 miles through the night to Madison, where he caught a bus to the Toronto airport. He said he barely got through Canadian customs because he didn't have his driver's license, which he had thrown in the lake. He eventually boarded a flight to Paris and then to an unspecified country in Asia. After landing in that country, a woman picked him up. They spent a couple days in a hotel, and he later took up residency in the country of Georgia, according to the complaint and a probable cause statement. Investigators contacted Borgward through information they found on a laptop he left behind, including a photo of the woman he traveled to meet. He told investigators he had to leave the laptop behind to make his death believable, but left too much information on it, according to the complaint. Podol said in November that investigators found passport photos, inquiries about moving funds to foreign banks, and communication with a woman from Uzbekistan. They also discovered that Borgward took out a $375,000 life insurance policy in January. Podol said the policy was for his family. The sheriff's office had said the search for Borgward's body lasted more than a month and cost at least $35,000. Borgward told investigators he often checked the news for updates on his disappearance and thought the search would only last a few weeks, according to the complaint. Borgward told investigators that he knew police would find him, but he wanted to delay their efforts for as long as he could, according to the complaint. Podol announced in November that investigators had made contact with Borgward and were pulling at his heartstrings to come home. The sheriff told reporters during a news conference that Borgward returned to the U.S. willingly and turned himself in at the Green Lake County Justice Center on that Tuesday afternoon. He declined to detail Borgward's return trip, saying only that he got on an airplane. He also declined to elaborate on what drove Borgward to return. That's going to be up to him someday, the sheriff said. We're not going to release that. We brought a dad back on his own. So he fakes his death, turns himself in, and he wants to represent himself in court. Not a good idea. In fact, I stand by a statement I made so long ago. We've seen the chaos with Darrell Brooks. We've seen the chaos that started with Sarah Boone, whom I'm gonna talk about a little bit later. Now this guy wants to try to represent himself in court. Not a good idea. Not an idea I would recommend. More details coming. Next, murder charges have been officially dismissed against Margaret Rudin, also known as the Black Widow of Las Vegas. Murder charges have been officially dismissed against Margaret Rudin, also known as the Black Widow of Las Vegas. The charges were dismissed in court with prejudice, meaning she cannot be tried for these charges again. I'm very happy, I'm very relieved, but I keep looking over my shoulder, said Rudin. The legal effect is that Margaret has never been convicted legally of any crimes, and she can never be re-prosecuted, said co-counsel for Rudin, Adam Breeden. The disappearance of wealthy Las Vegas real estate developer Ron Rudin nearly 30 years ago, and the subsequent conviction of his wife Margaret for his murder was one of Nevada's most infamous trials. Ron went missing in 1994. Weeks later, his burned and decapitated remains were found in a desolate area near Lake Mead. Years later, facing indictment, Margaret went on the run for 2 years. She was eventually caught during a nationwide manhunt after she changed identities several times. She was charged with her husband's murder in 2001 and sentenced to life in prison with the possibility of parole after 20 years. Margaret steadfastly maintained her innocence throughout her incarceration. In 2022, the United States District Court of Nevada found Margaret had not received a fair trial and was wrongly convicted and entitled to release. Margaret is currently litigating wrongful conviction action against the state of Nevada for her 20 years of wrongful incarceration. Her attorneys will file an amended version of this wrongful conviction complaint against the state, including the dismissal of charges. Her filing was made possible because of a state statute amended in 2019 to address the rights of people wrongly convicted. They are looking for compensation to cover the costs and damages associated with this case. Plus, they are looking for acknowledgement that Margaret is innocent. Scripps News Las Vegas asked Margaret if she believes she'll receive a certificate of innocence. Knowing Nevada and the way they've treated me so far, no, she said. I'd like to see it before I die. The state and Rudin's attorneys will have an official order worked out in the next 10 days for the judge to officially sign. Scripps News Las Vegas reached out to the Clark County District Attorney's Office for comment on the case and dismissal of charges and have yet to hear back. The Nevada Attorney General's Office told Scripps News Las Vegas they have no comment. So as it stands right now, they can never try Margaret Rudin again for her husband's murder. Do I believe she's innocent? Don't know. I haven't heard a lot about this case. I'm gonna have to do my own research leading up to this and decide for myself. Alright, a trial currently going on right now is the Killing in a Convenience Store trial in North Carolina. The state of North Carolina versus Taseer Taz Zarqa. Now, a convenience store owner in North Carolina standing trial on charges he murdered a customer. Tyzir Taz Zarka is charged with the second-degree murder of Mark Thomas Garrity Jr., who was stabbed to death outside of Zarka's store in Raleigh in April 2023. A store employee told WNCN that Zarka had accused Garrity of stealing a Gatorade, which the victim denied. A medical examiner's report reviewed by Court TV alleges that after arguing, Zarka pulled out a folding pocket knife and stabbed Garrity 3 times. One of the wounds penetrated the victim's heart. Garrity was able to get out of the front door before collapsing on a sidewalk. A bystander attempted CPR, but Garrity was pronounced dead at the hospital hours later. Prosecutors have indicated they plan to show jurors surveillance video from inside the store that shows the attack, as well as Garrity appearing to steal the items. An unopened drink was found in Garrity's bag. Zarka, through his attorney, had said he was acting in self-defense, according to a report from WRAL. And according to the News and Observer, Garrity had a criminal record and had previously pleaded guilty to felony breaking and entering. This trial will pick up on tomorrow at 9 o'clock. Next, Donna Adelson's new defense attorney proposes a trial date. The date is to be set in June. Donna Adelson returned to court Tuesday. Returned to court with this time with her new legal team as she prepares to face charges she orchestrated the murder of her former son-in-law. Adelson is the 5th person facing charges for the murder of FSU law professor Dan Markle, who was gunned down in his garage on July 18, 2014. Her son Charlie Adelson was convicted of the murder along with his ex-girlfriend Catherine Magbanua and hitmen Sigfredo Garcia and Luis Vieira. Donna's new attorneys Jackie Fulford and Josh Zellman have replaced her former legal team, which was abruptly forced to resign in September. Donna was previously represented by Daniel Rashbaum, who had also represented Charlie at his murder trial. On the eve of the trial, Rashbaum withdrew from the case, citing conflict of interest, and his co-counsel was dismissed for the same reasons. Fulford suggested a June 16th start date for Donna's trial with an extended expected end date of July 2nd. Zellman told Judge Stephen Everett that the team is still working to get all the discovery and transcripts, and noted that the prosecutor's office will be working with them to get what they need, since Donna's previous legal team has not given them everything. Judge Everett said all discovery and deposition transcripts should be turned over by the next case management meeting scheduled for February 11th. So we will see what becomes of that. Some good news. Much needed good news. Hana Kobayashi, who vanished on November 8th while traveling from Maui to New York City, has been found safe, according to police. Kobayashi vanished last month in Los Angeles, and her disappearance prompted a massive search and a missing persons investigation. It was not immediately clear where she was found, but police previously said she had voluntarily crossed the border into Mexico. We are happy to learn that Hannah has been found safe, the LAPD said in a statement. Now that we have this new information, this has become a private matter, and we will wrap up our investigation. Kobayashi, a budding photographer from Maui, was heading to New York City on November 8th for a new job and to visit relatives when she missed a connecting flight during a stop at Los Angeles International Airport. She told her family she was sleeping at the airport that night and texted them the next day to say she was sightseeing in Los Angeles. Her family reported her missing to law enforcement on November 11th after relatives received strange and cryptic, just alarming text messages, according to her aunt, Lori Pigeon. Once the family started pressing, she went dark, Pigeon told the Associated Press late last month. After the text on November 11th, her phone just went dead, Pigeon said. Family members, friends, and local volunteers searched for Hannah in Los Angeles. Hannah's father, Ryan Kobayashi, was among those who flew in from Hawaii to help in the search. He was found dead on November 24th in a parking lot near LA International Airport, according to the county medical examiner. Police said Kobayashi walked into Mexico at the San Isidro border, crossing about 125 miles southeast of Los Angeles on November 12th, the day after her family reported her missing. Authorities made the announcement after reviewing security video from U.S. Customs and Border Protection. Kobayashi disappeared voluntarily as she sought to step away from modern connectivity, LAPD Chief Jim McDonnell, the LA Police Chief, previously said. All I can say to that is thank God that she is found safe. And somebody mentioned in the come on, Ernest, in my community tab on this story that the real tragedy is that her father had passed, and that I agree with. Next up, two luxury real estate brokers and their brother have been charged with luring, drugging, and raping dozens of women over more than a decade. Two luxury real estate brokers and their brother charged with luring, drugging, violently raping dozens of women over more than a decade, according to a federal indictment in Manhattan, unsealed. State charges were filed in Florida against two of the brothers and a third man stemming from 3 alleged sexual assaults. Federal prosecutors alleged that in the New York indictment that Orrin and Tal Alexander, known for brokering deals on high-end properties in New York City and Miami, and sibling Alon Alexander, used their wealth and influence to take advantage of women from at least 2010 to 2021. The brothers, who all reside in Miami, used deception, fraud, and coercion to entice victims to travel with them or attend parties or events, often covering flights, hotels, and other expenses, according to the indictment. They also at times used the promise of a romantic relationship, it said. The women were then drugged and raped by one or more of the brothers, as well as other men, before being sent away with concert tickets or other luxuries. This conduct was heinous, U.S. Attorney for the Southern District of New York, Damian Williams, said at a news conference in Manhattan. The brothers typically met their victims on dating apps, through social events, and at bars and at nightclubs, but they also used party promoters to source women, according to Williams. He added that the women were often provided drugs, including cocaine, psychedelic mushrooms, and CHB. The brothers even surreptitiously drugged some of the women's drinks, leaving them physically impaired and unable to fight back or escape from the sexual assaults, prosecutors said in their indictment. In some instances, the defendants physically restrained and held down their victims during the rapes and sexual assaults and ignored screams and an explicit request to stop, the indictment said. In the Florida cases, state prosecutors described one incident in December of 2016 as a gang rape of a woman who said she was invited to a barbecue at Alan Alexander's Miami Beach apartment only to discover no one there, save Alan, his brother Orrin, and another relative, Ohad Fisherman, who remains at large. The woman, who was not named, said she was led into a bedroom where Fisherman held her down and the brothers argued over who would rape her first, as she pleaded with them not to assault her, according to the Miami-Dade State Attorney Catherine Fernandez-Rundle. The second incident, in October 2017, involved a woman who said she was sexually assaulted by Orrin Alexander at his apartment after drinking a glass of wine that left her feeling weak and unable to control her body, according to prosecutors. They said the third incident happened in October 2021 and involved a woman who said she was assaulted by Orrin Alexander after going back to his residence with friends following dinner. Williams, the U.S. Attorney in New York, said the three brothers were arrested in Florida and will appear in Miami federal court before being brought to New York. He declined to say if others will be charged, but urged any other possible victims to come forward. Meanwhile, lawyers for the brothers denied the charges, which include one count of engaging of sex trafficking conspiracy for each sibling. Orrin Alexander is innocent, attorney Susan Nichols wrote in an email. The evidence will show that neither he nor his brothers ever committed a crime. My client will be entering a plea of not guilty and dealing with these charges in the appropriate forum, the courtroom, responded Isabel Krishner, a lawyer for Alan Alexander. Joel DeNaro, a lawyer for Tal Alexander, declined to comment. The elder brother appeared in Miami federal court and will have a detention hearing. As prosecutors argue, he is a danger to the community and a flight risk. The two other brothers are in state custody and are expected to appear in court. Representatives for a number of women who filed lawsuits earlier this year claiming they were violently raped by the brothers welcomed the charges. We are glad to hear there will finally be some measure of accountability for the Alexander brothers and justice for their many victims, lawyer David Gottlieb wrote on X, formerly known as Twitter. We applaud all the survivors who have had the strength and courage to speak up about their unimaginable experiences after years of pain and suffering. Tal Alexander, 38, and 37-year-old Orrin Alexander first worked as a team under real estate giant Douglas Elliman, listing properties for Kim Kardashian and Kanye West, Liam Gallagher, and Lindsay Lohan. In 2022, they started a new company called Official. Alan Alexander, who is Orrin's twin brother, attended law school and joined the family's private security business. So now this is what I mean. Unlike the Diddy and Jay-Z lawsuit, we have plenty of women not waiting so long, but they're telling their story right there and then. I'm gonna keep an eye out on this one and let you know if there are anything else to be added. Next up, we have closing arguments in the Van Life and Death Murder Trial, Vermont versus Joseph Ferlazzo. I'm not going to play all those closing arguments because that'll take up too much time, but I will break down. No, wait. In fact, not only will I said I wasn't going to play the closing arguments, which is true. But I never said anything about the verdict. In fact, I'm gonna go ahead and take you to that right now. Joseph Ferlazzo's fate is in the hands of a jury, and the verdict has been reached.
We have some breaking news for you. There is a verdict in the case we have been watching out of Vermont. This is the case for Joseph Ferlazzo. The jury did deliberate for 3 hours and 30 minutes. The judge has just called for the jury. Let's go in.
Please be seated. Ms. Reno, I understand the jury has reached a verdict. How do you find Mr. Ferlazzo on the count of first-degree murder, guilty or not guilty? Ms. Jantz, would you like us to poll?
I would, please.
And Mr. Zago, is that your verdict, guilty or not guilty?
All right, if you've noticed that we can't hear the audio right now, they are saying the jurors' names. So, of course, we cannot reveal the names of the jurors in this case. But what we can tell you that we have heard the verdict, and he is being found guilty. The jurors have found him guilty of first-degree murder. 7 women and 5 men have been deliberating this case. Took them over 3 hours to reach this verdict, saying that he's guilty of first-degree murder for the death of his wife, 22-year-old Emily. Let's listen again.
Thank you so much for your service. It's clear you were very thoughtful throughout the trial. Really appreciate how you were always on time, you were always listening, taking notes, and really studying the evidence as it was coming in. Really appreciate your time in this case. Thank you, and you're excused with great thanks of the court.
So just as you heard it, Joseph Ferlazzo Jr. has been found guilty of murdering his wife, who was killed while they were on vacation. Joseph Ferlazzo fatally shot 22-year-old Emily Ferlazzo in October 2021 while they were visiting Vermont for their one-year wedding anniversary. Emily's family reported that she was missing when he returned from their trip alone, claiming that Emily had left after they had an argument. Joseph ultimately confessed to shooting Emily twice after an argument and dismembering her body. Emily's remains were found in a bathroom of the couple's camper. He testified at trial and claimed self-defense. According to an affidavit obtained by NBC Boston, Emily's mother told investigators there was a history of domestic violence in their marriage. In 2023, Joseph was reportedly ordered to pay Emily's family $1.5 million in a wrongful death suit. While no sentencing date has been scheduled, Joseph does face a minimum of 35 years imprisonment and a maximum of life when he is sentenced. Once again, Joseph Ferlazzo, guilty of the first-degree murder of his wife Emily. When I get word of when the sentencing date will be, you'll be the first to know. And speaking of a verdict watch, we're back on verdict watch again. The missing student murder trial, Mississippi versus Sheldon Timothy Harrington Jr., charged with murdering Jimmy J. Lee, though the victim's body has never been found. Let's see what the jury has to say in that case.
We're going to start with the case in Mississippi for Sheldon Tim Harrington Jr.
About 9.5 hours, I think. Have you reviewed all the evidence thoroughly? I'm going to declare a mistrial. I appreciate your effort.
All right, so mistrial declared by the judge Wednesday after over 9 hours of deliberations. The jury was unable to reach a unanimous decision. Harrington, seen here after the court made that declaration, showed little emotion as he left the courtroom with his defense team. While the family of victim Jimmy J. Lee were visibly very emotional. Jay was a prominent member of the LGBTQ community at Ole Miss, and his body has never been recovered, but a court has declared him legally dead. Now, we want to turn to North Carolina.
So this jury is deadlocked in that case. They were unable to reach a unanimous verdict. So looks like we're going to. This young man will be tried again at a later date, and hopefully that jury will find will be able to come up with a unanimous verdict. In the meantime, a mistrial declared in the trial of a man accused of murdering a missing University of Mississippi student. Sheldon Timothy Harrington Jr. was charged with the murder of Jimmy J. Lee III, who disappeared on July 8, 2022. Harrington had pleaded not guilty to the charges. Indictment reviewed by Court TV alleges that Harrington murdered Lee while engaged in kidnapping. And on December 11, a judge declared a mistrial in his case after the jury failed to reach a unanimous verdict. Harrington will remain on his current bond while awaiting a second trial. Next up, in celebrity legal news, country star Morgan Wallen takes a plea deal in a chair throwing case. He was given 2 years of probation in a chair throwing case while in Nashville. Let's go to court right now for that plea.
You solemnly swear or affirm the testimony you're about to give before the court is the whole complete truth, so you got it.
I do. I need to speak loudly and clearly. You've got to take down everything you say in person, so you got to be able to do it. Yes, sir. Yes, sir.
All right, sir. I have been provided with petition to enter a plea of guilty in your case. I need to ask you several questions to make sure you understand the contents of this plea petition, to make sure that you're competent to enter the plea, and make sure you understand the rights you have as a criminal defendant. While we go through these proceedings, you've already been instructed to answer my questions verbally so the court reporter can take down your response. I also want to instruct you that if I ask a question you don't understand or say something you don't understand, please stop me. These are very serious proceedings. I want to make sure that you and I are on the same page. And secondly, if at any time you need to consult with your attorney, just let me know and you'll be able to consult with him privately before we go any further. Have you understood my instructions?
Yes, ma'am.
All right. How far did you go in school, sir?
I graduated high school.
So you are able to read and write?
Yes, ma'am.
Are you taking any medication, prescription over the counter, or otherwise?
No, ma'am.
Have you consumed any alcoholic beverage or other intoxicant in the last 24 hours?
No, ma'am.
Have you been diagnosed with or are you suffering from any mental illness or mental disorder?
No, ma'am.
Is there any reason you can think of that would affect your ability to understand what you're doing here today?
No, ma'am.
You are under oath, and that means you've sworn to tell the truth. Do you understand that?
Yes, ma'am.
You have provided the court with a plea petition that has a signature. Did you sign this petition?
Yes, ma'am.
And before you signed it, did you have an opportunity to read it in its entirety to yourself or to have it read to you by your attorney or some combination of those things?
Yes, ma'am.
And during the time that you were reading the petition or it was being read to you, if you had any questions, were they answered to your satisfaction?
Yes, ma'am.
Do you believe you fully and completely understand the contents of this plea petition as you stand here today?
Yes, ma'am.
Sir, you are charged by way of what's called a criminal information. I need to talk to you about that just a little bit. Anytime you're charged with a crime, you have a right to have the Davidson County grand jury hear your case. The grand jury is a body that investigates whether a crime has occurred, what level of crime, and whether or not you had any involvement in the crime. By signing a criminal information, you are waiving your right to have your case presented to the Davidson County grand jury. Is that right?
Yes, ma'am.
All right. You are charged in case 2024 I-687 with 2 counts of misdemeanor reckless endangerment. Those each carry a maximum punishment of 11 months and 29 days in jail and a fine of up to $2,500 on each count. Is that your understanding of what you're charged with and the punishment you could receive?
Yes, ma'am.
You understand you're charged with more than 1 count, and I want to make sure you understand if you were convicted of 2 counts, you would receive a separate sentence for each of those counts. Do you understand that?
Yes, ma'am.
I understand. Do you understand what it takes under the law to be found guilty of what you're charged with, sir?
Yes, ma'am.
I understand that you are entering a plea of guilty to 2 counts of reckless endangerment. You will receive a sentence of 11 months and 29 days, all suspended except 7 days incarceration, which will be served in a DUI education center. The remainder of that sentence will be served on supervised probation. These counts run consecutive to each other, that is, one after the other, for an effective sentence of 2 years. And the sentence is pursuant to judicial diversion, which we will talk about a little bit later. Is this your understanding, sir, of what you're pleading guilty to and the punishment being imposed?
Yes, Your Honor. We talked about the formal conditional guilty plea, but yes, he understands that.
All right, but those are the offenses that he understands he's pleading guilty to and the sentence, which is a 2-year sentence.
Yes, ma'am.
All right. Do you have any questions at all about what you're charged with and the punishment you could receive, that is the maximum punishment, and what you're pleading guilty to and the punishment that is being imposed?
No, ma'am.
Before you decided to enter this plea, did you have enough opportunity to speak with your lawyer about the facts and circumstances that led to this arrest?
Yes, ma'am.
And during those discussions, did he talk to you about the law that applies to your case as well as the evidence the state says it has against you?
Yes, ma'am.
And during those discussions, did he explain the defenses you might have to these charges, that is, the evidence you would use to overcome or negate the evidence the state says it has against you?
Yes, ma'am.
And during those discussions, if you had any questions, were they answered to your satisfaction?
Yes, ma'am.
Do you have any complaints at all about the representation your lawyer has provided?
No, ma'am.
All right, sir. The following questions address the rights you have as a criminal defendant, because when you enter these pleas of guilty, you are waiving or giving up those rights. So please listen carefully so I can make sure you are knowingly giving up your rights. First of all, do you understand you have the right to continue to plead not guilty, demand a trial by jury, and require the state to prove your guilt beyond a reasonable doubt?
Yes, ma'am.
And do you understand if you did demand a trial by jury, you are entitled to a public and speedy trial by jury?
Yes, ma'am.
Do you understand if you were to demand a trial by jury, it would be the state's responsibility to prove your guilt beyond a reasonable doubt, but you have no obligation to prove that you're innocent, because under the law, you are presumed to be innocent?
Yes, ma'am.
Do you
understand? Morgan Wallen entering a plea there. We do have to hit our break. We're at the top of the hour. Our thanks to Tamika Grabowski for her analysis this hour. More Morgan Wallen plea hearing after this. We are paying attention to several major trials happening here on Court TV. Here's a look at what we're tracking this hour. In Vermont, closing arguments are underway in the Van life and death murder trial for defendant Joseph Ferlazzo. He took the stand yesterday to tell the jury he shot his wife in self-defense in their van after a fight broke out during a vacation celebrating their first anniversary. We're also looking at the courtroom in North Carolina. It's day 2 of testimony in the convenience store owner case accused of killing a customer. It's Taz Zarka, who's accused of stabbing Mark Garrity after Zarka allegedly witnessed Garrity stealing a Gatorade. And in Tennessee, country music star Morgan Wallen back in court today for a plea hearing, and that's what we're going into now, picking up right where we left off.
jury, you are entitled to a partial trial by a jury of your peers made up of citizens of Davidson County.
Yes, ma'am.
Do you understand, had this case gone to trial, you would have the right through your attorney to cross-examine any witness the state called to testify against you? He could question their memory, their truthfulness, and bring forward any pertinent facts about your side of the case.
Yes, ma'am.
And do you understand you have the right to use the subpoena power of the court to require the attendance of any witness that could testify for you if there were such witnesses?
Yes, ma'am.
Do you understand, had your case gone to trial, you could testify on your own behalf, but only if you chose to do so, because you cannot be made to testify and give evidence against yourself. And if you decided not to testify, the jury would be instructed that it could not consider your decision not to testify as evidence of your guilt or for any other purpose.
Yes, ma'am.
Do you understand, had you been found guilty at trial, you would have the right to have a jury set any fine greater than $50, and the court would set your punishment at a separate sentencing hearing?
Yes, ma'am.
And furthermore, if you were convicted, you could appeal your conviction as well as any punishment imposed to a higher court. And if that higher court found you did not receive a fair trial or a fair and proper sentencing hearing, that court could grant relief, including the possibility of a new trial.
Yes, ma'am.
And do you understand, sir, that through all of the proceedings I've just gone over, you have the right to an attorney? And if you could not afford an attorney, I would appoint one for you, and that includes if you went to trial, were convicted, and wanted to appeal that conviction.
Yes, ma'am.
Do you have any questions at all about the rights you have as a criminal defendant?
No, ma'am.
Do you understand, if I accept this plea of guilty here today, that ends your case in this court once and for all? There is no further discussion, there is no jury trial, no sentencing hearing, and no appeal.
Yes, ma'am.
Sir, you are pleading guilty pursuant to what we call judicial diversion. That is a particular statute for first offenders that allows you, if you successfully complete all of the terms of your probation and have no other arrest or problems with the law, you may then petition the court to expunge all public record of these offenses. On the other hand, if you do not successfully complete your probation or you have other arrests or trouble with the law, you run the risk of losing your judicial diversion status. And if that happened, these offenses convert to convictions on your record. Do you understand that, sir?
I understand.
Has anyone threatened you with anything or promised you anything in order to get you to enter this plea?
No, ma'am.
Are you entering this plea of guilty because you are guilty, sir?
Yes, ma'am.
All right, for counsel, Mr. Robinson, do you believe that your client understands the nature of the charge against him, the law that applies to the charges, the pros and cons of entering the plea versus going to trial, and that he is entering the plea freely, knowingly, and voluntarily?
Yes, Your Honor.
All right, thank you. Let's do the facts, please.
Your Honor, if this matter proceeded to trial, the proof would be that on April the 7th of 2024, the defendant was at Chief's Bar and Restaurant located at 200 Broadway Avenue. The defendant was on the 6th floor of the rooftop bar. The defendant picked up a chair, threw it off the 6th floor. The chair landed on Broadway, approximately 3 feet from where Officers Gavin Treese and Officer Yaroslav Holokov were standing, placing them in imminent danger of death or serious bodily injury. All these events happened in Nashville-Davidson County, and based on those facts, the state would recommend the previously announced agreement. And Your Honor, I'd like to say that Officers Gavin Treese and Officer Holokov were both consulted about this plea and both approved it.
All right. Thank you. Mr. Wallen, did you hear the facts as read by the Assistant District Attorney?
I did hear that.
Are those facts true and correct?
Substantially, yes.
Are you waiving your right here today and entering a plea of guilty in your pending case?
Conditionally guilty, yes.
Conditionally guilty, yes, ma'am.
In case number 2024-I-687, where you were charged with 2 counts of reckless endangerment, how do you plead, sir?
Conditionally guilty.
All right. Mr. Robinson, anything further before I accept the plea?
No, Your Honor.
All right. Mr. Wallen, based upon your plea of guilty, I do find you guilty. I find there is a factual basis for the plea, that you are competent to enter the plea, and that you're doing so freely, knowingly, and voluntarily. So I will place into effect the previously announced plea agreement. That concludes this proceeding.
Thank you.
Thank you, Your Honor.
There you have it. The country music star walking out of the courtroom after agreeing to plead guilty to the reckless endangerment charge against him for throwing that chair off of that 6th floor rooftop bar. Let's bring in our guest who's here in studio, criminal defense and civil attorney Jesse Law is with us. So good to have you in studio.
Thank you.
I got to ask you this just first off. When he's saying conditionally guilty and substantially when he's saying that he agrees to it, what does that signal to you?
I really don't want to plead guilty. I really am not guilty, but it's based on the best advice I've got from my lawyer. This is the best route to go right now. Resolve the matter, put it behind me. I don't get jail time. I get to be on probation, or I do community service or something. But I just take the easy path to resolve a criminal matter against me. And possibly, I'm not that familiar with conditionally guilty, but I think it may not have permanent ramifications on his record. But y'all can check into that, because
it's almost like a no-low.
It's like a no-low contendere, no contest. If you are qualified for such a plea, you can put that in, and it won't go on your permanent record, and one can't use that against you if you are ever arrested again in the future. So it's a cop-out.
Could be.
Yeah.
So he faced 3 Class A misdemeanors there in Tennessee. 129 days, what the judge made sure he understood he could have faced if he had gone to trial on this. We're understanding 2 years probation and perhaps 7 days in jail behind bars. You surprised that if there is the 7 days, that there is any jail time for someone who is as high profile as Morgan Wallen?
Well, I think it might be 7 days in jail if the judge wants to impose him, but she could also give him credit for the time he's already served. So he may be in jail for a minimal amount of time, not necessarily all 7 days. And 2 years probation, she probably tacked it on a consecutive for each count. And that's not unusual. And the good thing about probation also is if you complete all your conditions, he can petition the court and more likely than not be granted a non-reporting probation, or probation could terminate if he's been a good boy, finishing all his conditions with no complaints.
How much do you think it exacerbates things that there were police officers nearby? Whether or not he knew that throwing that chair over the rooftop was going to land 3 feet away from officers, but when you're talking about prosecuting a case like this that is so public because of his fame, how does that play into it?
I think the seriousness totally undercuts his ability to put out a strong defense in this case. Because the officers were nearby, it could have been a more egregious situation if someone was actually struck. And then you have officers, who doesn't believe officers, right? And especially in a trial. So when you have this kind of situation and you are potentially could have harmed someone in a uniform, it totally undercuts his ability to put up a solid defense.
So Morgan Wallen pretty much got off lucky. He pled guilty to 2 counts of reckless endanger in the chair throwing incident earlier this spring. In the plea agreement, he pleaded conditionally guilty to those 2 counts and was sentenced to a mere 7 days in jail. That will be served at a DUI education center, followed by 2 years of probation. Morgan Wallen, if I were you, I thank God that it's not a lot longer than that, because that could have turned totally went in a totally different way.
I'm not quite sure how to help you with that.
That was my echo. Next on the docket, a polygamous leader connected to Warren Jeffs gets 50 years in prison. Oh boy. Samuel Bateman, whose small group was an offshoot of the set once left by Warren Jeffs, pleads guilty to a years-long scheme. A polygamous religious leader who claimed more than 20 spiritual wives, including 10 underage girls, was sentenced to 50 years in prison for coercing girls as young as 9 years old to submit to criminal sex acts with him and other adults, and for scheming to kidnap them from protective custody. Samuel Bateman, whose small group was an offshoot of the sect once left by Warren Jeffs, had pleaded guilty to a years-long scheme to transport girls across state lines for his sex crimes, and later to kidnap some of them from protective custody. Under the agreement, Bateman pleaded guilty to one count of conspiracy to commit transportation of a minor for sexual activity, which carries a sentence of 10 years to life imprisonment, and one count of conspiracy to commit kidnapping, which is punishable by up to life imprisonment. He was sentenced to 50 years on each count to be served concurrently. The rest of the charges were dismissed as part of the agreement. Authorities say that 48-year-old Bateman tried to start an offshoot of the Fundamentalist Church of Jesus Christ of Latter-day Saints based in the neighboring communities of Colorado City, Arizona, and Hilldale, Utah. The fundamentalist group, also known as the FLDS, split from the Main Street Church of Jesus Christ of Latter-day Saints after Mormons officially abandoned polygamy in 1890. U.S. District Court Judge Susan Brinovich sentenced Bateman after hearing statements in court by 3 teenage girls about the trauma they still struggle to overcome. Although they gave their names in court, the Associated Press does not name victims of sexual crime, and some appear to still be minors. You should not have the opportunity to be free and never have the opportunity to be around young women, Brinovich told Bateman, noting that for a nearly 49-year-old man, the 50-year sentence was effectively a life sentence. You took them from their homes, from their families, and made them into sex slaves, the judge said. You stripped them of their innocence and childhood. A short competency hearing that was close to the public was held just before sentencing to discuss the doctor's assessment of Bateman's mental health. The defense had argued that Bateman could have benefited from a maximum of 20 years of psychiatric treatment behind bars before being released. The girls told the court, sometimes addressing Bateman himself, how they grappled to develop relationships in high school, among other struggles. Now living with foster families, they said they had received much support from trusted adults outside their community. After the sentencing, the teens hugged and wept quietly. They were escorted out of court by a half a dozen men and women in jackets with the slogan, "Bikers Against Child Abuse," a group dedicated to protecting children from what it calls dangerous people and situations. A woman who sat with the teens said no one in the group would have a comment. There was no one in the courtroom who appeared to be a supporter of Bateman. The alleged practice of sect members sexually abusing girls whom they claim as spiritual wives has long plagued the FLDS. Warren Jeffs was convicted of state charges in Texas in 2011 involving sexual acts of his underage followers. Bateman was one of Jeffs' trusted followers and declared himself, like Jeffs, to be a prophet of the FLDS. Jeffs denounced Bateman in a written revelation sent to his followers from prison, and then tried to start his own group. I'm going to stop right there because of how crazy that case is, and I'm glad this guy got exactly what he got. Like the judge said, a sentence of 50 years, and he's nearly 40, and he was nearly 49 when he was sentenced. That is essentially a life sentence. Next, Karen Reed's retrial has been delayed ahead of key evidentiary hearing. The highly anticipated retrial for Karen Reed on charges she murdered her police officer boyfriend has been delayed as both sides prepare to head to court to argue over key evidence. Reed is facing several charges, including second-degree murder in the death of her boyfriend, Boston police officer John O'Keefe, who was found dead in the snow after a night out drinking. Prosecutors maintain that Reed struck him with her SUV and left him to die, while Reed's defense has maintained her innocence and has instead alleged that she is being framed amid a massive cover-up. Her first trial ended in a mistrial in July after the jury could not come to a unanimous decision. The retrial had been scheduled to begin next month, but after Reed and prosecutors submitted a joint motion requesting a delay, Judge Beverly Canone agreed to push the start. Both sides want additional time to prepare for the trial because of additional evidence and experts they plan to present. Prosecutors are trying to block Reed's defense from introducing some expert testimony from Dr. Marie Russell, who the defense has put forward as someone who will testify that O'Keefe's injuries were the result of dog bites rather than being hit by a car. Russell testified in Reed's first trial, but prosecutors have asked Judge Canone to exclude her testimony from the retrial. Her testimony will be the subject of a December 12th, wherein prosecutors will attempt to challenge her status as an expert and the testimony the defense wants to introduce. The hearing, known as a Daubert hearing, examines whether the proposed expert witness meets the 5 foundational requirements for admission in the court. Judge Canone will weigh whether the expert meets the requirements of relevance to the case, meeting qualifications, knowledge of facts, and reliability of principle. While the joint motion to delay the start of the trial proposed a new start date of April 1st, 2025, Judge Canone's order granting the delay notes that scheduling matters will be discussed at the December 12th hearing. So, we still wait. We still wait, and when we get word as to when that'll start, you'll know it. Next up, we have another sentencing to go to. This one's out of Georgia. Chloe driver accused of in the death of her 13-month-old daughter. Now the jury has her fate in their hands. So we're going to go to the courtroom right now for that sentence.
Joining us now, Chloe Driver's ex, baby Hannah's father, Ben Rosenrock, formerly known as Benjamin Ben Michael. He's joining us by phone as we had some connection problems earlier. So
I have continued to think about this case after the verdict, as I am sure all of us have. I have been aware that based on the law, that my only real discretion in this case is whether to sentence you to life without parole or life with the possibility of parole. I am aware, as Mr. Hathaway pointed out, that the parole eligibility in this state would dictate that you would serve 30 years of a life sentence before you were considered for parole.
this was a heinous offense with evidence that was so graphic and traumatic that I began to do research on what kind of support and help we could give the jurors who were having to consider it. A parent killing a child is something that just offends us on the deepest level. It is a wrong that just is unfathomable. It just cannot be understood. And it scares us because it is so contrary to just fundamental moral behavior and what we expect of the bonds between human beings. And I have all those thoughts. I have had all those thoughts in this case. I noticed throughout the trial and considered it as part of the tragedy, quite honestly, that there were really no family members here to support you, and that Mr. Ben Michael was not here interested in the outcome of what was going to happen to his child, the person who killed his child. That was a very interesting dynamic to me. So I'm glad to see him here today. You don't need to speak to me at this point, sir. Your opportunity to speak has come and gone. Although the response I just heard doesn't do anything to make the whole situation any less tragic. But as I said, I'm glad to have heard from Mr. Ben Michael and to honestly try to give him some benefit of the doubt, understanding that there is an impact on him that cannot be measured, as he put it, and just again an impact on the universe. One more child who never goes to school, never gets to have a boyfriend or go to the prom, never gets to decide what a career is. They're not words to talk about what a terrible thing it is. But I do also feel bound to consider the fact that if you had succeeded, we would not have been here. We would have read about a tragic, inexplicable murder-suicide. I have to take into account that 3 different psychologists testified as to your profound mental illness, the depths of your sickness, your illness. I have to take into account the fact that the jury found you guilty but mentally ill, because they obviously were aware they had the choice of imposing a different sentence. Different verdict, I'm sorry, a verdict of guilty that did not reference any of your mental illness. Georgia law, Georgia statute means that the guilty but mentally ill verdict gives the Department of Corrections some direction and some ability to continue to provide treatment for you, but that is in their discretion. There's no black and white law as to how a judge is to consider that verdict. I will note that the jury found that you did not meet the criteria of not guilty by reason of insanity. The law in Georgia has been the same for about 200 years now. Whether or not that ever changes because of changes in medical and societal understanding of mental illness and how to treat it, I do not know. The intersection between law and medicine can be, well, it does not always mesh well. Things evolve. We now have treatment courts for people with mental illness and addiction, substance use issues, and the law and the courts slowly come about in proper cases to figure out about treatment. I don't quarrel with the jury's verdict. I don't impose this sentence out of sympathy. But I do think under everything that I heard, the sentence needs to take into account the possibility that in 30 years, there may be different treatment modalities, different recommendations, different possibilities for your rehabilitation. I think the notion that you are cured because you're taking medication regularly now is something that I don't accept. I believe everyone acknowledges that, or at least based on the law and the testimony we heard in this case, that borderline personality disorder, for example, is a deep sickness that is not treated just by medication, for example. You were treated in order for you to gain competency to be able to actually go to trial. I don't think anybody who's dealt with anybody with mental illness is naive enough to suggest that you're cured. And I know I don't mean that as a criticism or a punishment. It's just reality. You did a horrible thing. But based on the evidence at trial and based on particularly the mental health testimony, the court will impose the following sentence as to count 1, malice murder, life in prison with the possibility of parole. Count 2 and count 3 are vacated as a matter of law, in that you cannot be sentenced to more than one murder count when there is only one victim. Count 4 merges into count 1. I agree with the state that count 5 does not merge into count 1, as it contains a different element, that is, that the victim is a child under the age of 18. That is not an element of malice murder specifically. So as to count 5, the court imposes a sentence of 20 years to serve in the state prison system concurrent with count 1. You have a right to appeal this conviction. You have a right to file a motion for a new trial requesting other post-judgment relief. You must file any such notice of appeal or motion for a new trial within 30 days of sentencing. You are entitled to have a lawyer represent you, and if you cannot afford to hire one will be appointed to represent you. I know Ms. Trethaway and Mr. Kessler are familiar with the procedures of our Indigent Defense Office as to how new counsel would be appointed to represent you moving forward. I would request that that Senate, that the council, if you will remain with us, and we will keep Ms. Driver, we can keep her here to get the minutes prepared, reviewed, signed, and get that taken care of before Ms. Driver is taken away from the jail, or the holding cell. Yes. All right. Thank you all.
Thank you.
So, Chloe Driver sentenced to life in prison with the possibility of parole, all after being convicted of the stabbing death of her 13-month-old daughter. She'll be eligible for parole after 30 years. Honestly, I think, in my opinion, she should be behind bars for life, no parole, simply because of the fact that a child was involved. But that, like I said, but that's just my opinion. Next, Alex Murdaugh is appealing his conviction, citing clerk and prejudicial evidence. Lawyers for Alex Murdaugh are taking two paths to appeal his murder convictions for killing his wife and son, saying that a court clerk pushed a guilty verdict to jurors to sell books, and that the trial judge allowed improper evidence, like the disgraced South Carolina's lawyer financial terms. The 132-page appeal was filed this week before South Carolina Supreme Court. Prosecutors will have time to respond, and the justices have to read all the material around the 6-week 2023 trial, meaning a hearing is likely months away. The appeal extensively details arguments that have already been made, either through objections during the trial or a bearing this year at which jurors were questioned about comments made by Colleton County Clerk Becky Hill during the trial. Murdaugh's lawyers wrote his murder convictions need to be overturned because the public needs more than just social media fed ideas about the details of a crime they did not witness. Providing Murdaugh with a fair trial that every citizen of South Carolina would expect for himself is necessary to assure all that no one, powerful or humble, innocent or guilty, hated or beloved, is proscribed from due process and equal protection of the law, according to the appeal signed by both of Murdaugh's chief lawyers at his trial, Jim Griffin and Dick Harpootlian. 56-year-old Murdaugh is serving life in prison for the shootings of his wife Maggie and younger son Paul outside their home in 2021. He continues to adamantly deny killing them, including from the stand at his trial. Murdaugh and his family dominated the legal system and life in nearby Hampton County for generations, and prosecutors during his trial laid out how he used his power and prestige to get away with stealing from clients and his law firm and out of other jams from his life. In their appeal, the defense pointed out how little physical evidence connected Murdaugh to the crime. Investigators never found the rifle used to kill his wife and a shotgun whose blast sent blood and tissue all around the small room where his son was found dead. Only tiny amounts of blood were found on the clothes Murdaugh was wearing when he found the bodies, and no bloody clothes were found elsewhere. Murdaugh's defense said a state investigator shouldn't have been allowed to testify that markings on cartridges found at a shooting range on the family property matched those found at the killings, because he never proved the markings are unique to one gun. They said a blue raincoat with a tiny amount of gunshot residue shouldn't have been put into evidence because a witness testified about seeing Murdaugh with a blue tarp, not a raincoat. The defense lawyers, who also said the judge should not have allowed evidence from an investigator who said he spent a weekend tossing an iPhone around his office to determine whether the screen, which comes on with a light touch, might not come on with a more violent motion. The expert witness kept no data and did not record his experiments. Prosecutors suggested Murdaugh threw his wife's phone from his moving car as he drove away, but data from his SUV's computer showed the phone screen turned on 2 minutes before Murdaugh's vehicle passed the spot where the phone was found. About half the appeal deals with Hill, the court clerk. In January, Judge Jean Toll ruled that while she couldn't believe Hill's testimony as she didn't talk to jurors about the case during the trial, she also couldn't overturn the verdict based on the strength of some fleeting and foolish comments by a publicity-seeking clerk of court, because they didn't actively change the jurors' minds. At least 3 jurors said Hill At least 3 jurors told them to watch Murdaugh's testimony in his own defense carefully, and one said the suggestion appeared to indicate he was guilty and couldn't be trusted. A clerk of court from a neighboring county testified that Hill told her she was going to write a book about Murdaugh's trial and that a guilty verdict would probably sell more copies. The rest of the appeal dealt with trial problems, including the decision by the judge to allow 6 days of evidence about Murdaugh stealing from clients and his law firm after prosecutors successfully argued a possible motive for the killings was Murdaugh seeking sympathy to stop further investigations into missing money. The trial judge, Clifton Newman, said the jury was entitled to consider whether Murdaugh's apparent desperation and dire financial situation resulted in the killings of his family, and that he didn't think the financial crime evidence alone would persuade the jury to convict Murdaugh of murder. Defense attorneys strenuously objected at the time and in the appeal. In the court records filed, they cited cases in which appeals courts overturned murder convictions because evidence of infidelity or spousal abuse were allowed in trials, but prosecutors couldn't directly link them to the killings. Here, the state was improperly permitted to introduce Murdaugh's alleged financial crimes solely to impugn his character, to bolster its otherwise weak case, his lawyers wrote. Even if Murdaugh gets a new murder trial, he won't walk out free. He has been sentenced to 40 years for pleading guilty to stealing millions from his law firm and from settlements he gained for clients on wrongful death and serious injury lawsuits. Murdaugh promised not to appeal that sentence as part of plea deals. So I guess we have to wait to find out if that conviction on murder charges will be successfully appealed, or will the sentence stick? And finally, this is appropriate, ladies and gentlemen, Sarah Boone gets the last word. In a 28-page letter, Sarah Boone told Judge Michael Cranick that she is happy to be free from his corrupt court and malevolent judicial grip. Before I even touch the article, I'm going to go to the Honorable Judge Ashley Wilcott as she talks to retired Judge Larry Seidlin and get his reaction to Sarah Boone having the last word.
Now, let's get to our top story for you. We have more on that. Shocking letter convicted killer Sarah Boone hand wrote to the Honorable Michael Cranick. She blatantly disrespects him, writing in part, quote, "I was hoping to have been graced with your forgiveness, understanding, and consideration in any level or degree. For me, unfortunately, and regardless of when I spoke on my behalf or the number of, your ignorant mind was already made up." She goes on to say, "By your clear error and full-blown unfair bias against me, since your involvement in my crucible case as a whole, I've been unsuccessful in receiving anything from you as a supposed fair and neutral judge, except for your wish that I spend the rest of my life in prison. Please know and always remember, Mr. Cranick, I forgive you." Boone ends the letter by writing, quote, "I am not a murderer, I am a survivor." Now, I said 28 pages, there was a lot in there, and we have a very special guest joining us to unpack it and react to this horrific note. Retired Judge Larry Seidlin on the show. Judge, good morning. Wonderful to have you back on Opening Statements. May I start with your
Good morning,
thoughts?
Julie. I'm retired as a judge, but I'm working hard.
We know you are. We know you are. And I know many of...
I'm working hard as a lawyer. I represent a lot of... Yeah.
Oh, that's great. That's great, Judge. We have a little bit of a delay, so I want to tell everybody if it sounds a little bit off. That's why, just the technology. And so many people remember you presiding over the Anna Nicole Simpson case, and so you rose to fame, and you've been beloved by so many across the country ever since. Could we talk a little bit about Ms. Sarah Boone in Florida? What are your thoughts on this letter and how she blames and disrespects the judge?
Well, she writes this 28-page letter. You remember Shakespeare's Hamlet with Ophelia giving all these soliloquies. This woman is a full-fledged nut. The judge is not going to read the whole 28 pages because as a judge, you don't want to absorb the mental pain of these people. You don't want to wear yourself out. You don't want to get tired. So you read a few pages and then you turn to the sports section or the news. You don't want to. It's the ramblings of a nut, the musings of a mentally ill person. So there's no way I'm reading those 28 pages unless it's a love letter from my daughter Dax. I'm not reading.
Oh, that's awesome, Judge. And I have another portion.
I know it the way it really is.
Yeah. I've got another portion here. She says in the letter to His Honor, I'm no longer in your corrupt court. She calls it a corrupt court, and free from your malevolent judicial grip. This judge was so professional, so kind, and we know Sarah Boone is difficult. I'm sure you have many difficult people who've been before you, Judge, throughout the years. What do you think, if anything, this judge should do in response to this?
Well, she went through 8 lawyers, and as a litigant, if you're a party in a lawsuit, civil, criminal, it shows instability when you go through more than 1 or 2. And I tell my clients that 1 or 2, if you're going through more than that, it shows you got some mental problems. I still find it difficult that a person can write an ex-parte letter to the judge without it first being looked at by the prosecutor. It should be also looked at the prosecutor, and the prosecutor and that party should then set it as a hearing in front of the court. The court can have a hearing or just deny the letter. The smartest thing to do for the judge is to go radio silent, to do nothing. You don't want to give her any credence, any credibility. So you just don't do anything. It's part of her DNA. When you read these letters by her, and when I heard her give a speech in the courtroom, she just pulls words out of the dictionary. She's a one-worder, and she looks for pretty fancy words in the dictionary, and she strings them together. If you put a light bulb in her mouth, it would light up. She's completely off the wall.
Judge, I think she ought to look up the word narcissist in the dictionary. Perhaps she'd find a definition that sounds familiar for herself. Then again, most of them never see themselves as what they are. Judge, this is sage advice that you're giving Judge Michael Kranick in this case, to just do nothing, sit back. You referenced that awful speech Sarah Boone gave. We have a clip. Let's play it now.
I forgive George for beating me senseless, for trying to sleep because I had to go to work or my son's field trip the next day, for ruining my deceased family's heirlooms, traditions, and keepsakes, for drowning me in liquor and wine because I didn't want to drink, causing me to urinate on myself, then butting the end of the bottle in my face, giving me 2 black eyes and a bloody nose, for making me experience what it is to be sodomized, threatening to kill my friends and the neighbors when they checked on me to make sure I was alive and in one piece.
Judge Seidlin, what did you think of that speech she gave at sentencing? Have you ever heard anything like that throughout your career, either as a lawyer or judge?
I was a bad boy. As a judge, I wouldn't let them just go like they're in London, in Hyde Park, giving these rambling speeches. I would have cut it short. I would have been a little bit more rude. I'm not letting a meatball take over my courtroom. There's no way I'm going to give her that kind of audience. And she had an opportunity to leave her boyfriend, and many opportunities. And I know she was also abused by this guy. But you get on a Greyhound bus and you go to a different town. You go somewhere else. There comes a point where you have to have the strength, the courage to make a move, and not stick him in a suitcase where he suffocates. I mean, it's bizarre. And unfortunately, I think the pandemic took a lot of these mentally weak individuals and even sent them further into the abyss. We're surrounded by a lot of mental weak people. So, like the play One Who Flew Over the Cuckoo's Nest, you can't allow the weak to destroy the strong. So the main character in that play, he says, "Why am I here?" And the response was, "You're here because of people like us." You can't allow the weak to destroy the strong. You got to stay strong. You got to exercise, eat good, and try to be mentally and physically healthy. It's a battle every day, and we all suffer through it. But we got to keep doing it. I mean, I got clients that are off the deep end sometimes. They can always call me. I try to bring them back into the rails.
Sure. No, I know you do. I know you are a tremendous lawyer and judge. Everybody fell in love with you, as I said, when you presided over Anna Nicole Smith's case. And we're so delighted to have you now on Court TV. Please come back. Judge Larry Seidlin, thank you for everything this morning. We'll see you soon.
Oh, boy. I couldn't disagree with Judge Seidlin if I tried hard. Every word, whether it's written on paper or came right out of the mouth of Sarah Boone, is telling me everything I need to know about her. This is just another part of that what she read in her sentencing, ladies and gentlemen. By my reserving particular parts of this very true and meaningful statement, I was hoping to have been graced with your forgiveness, understanding, and consideration in any level or degree. For me, unfortunately, and regardless of whom I had speak on my behalf or the number of your ignorant mind was already made up. I have also added to my statement as a result of your blindness and impartiality, foremost, your disgust in me as being an outspoken woman, determined defendant, and proactive client, hoping the next time you put on your listening ears and do not unfairly oppress the next as you have so blatantly done me, quote, end quote. This is what being the so-called smartest woman in the room gets you. I'll say that again. This is what you get for being the so-called smartest woman in the room. Sentence of life in prison for murder. And that's going to do it for Bethea'S Byte Reloaded. Man, it felt good being back here. Alright. I'm gonna go ahead and wrap this up. So guys, I thank you all so much for taking your time to watch the video. Especially everybody on my replay gang. Love you to death. Like I said, it feels good being back here. 2 weeks is too long to be away from you guys. So, if you want to get a hold of me, hit me up. I'm on Facebook at Bethea'S Byte Reloaded. I'm on X, formerly known as Twitter, at EKB316, all caps. Here on YouTube, at Bethea'S Byte Reloaded. And yes, Reloaded is all capitalized. EKB316 on Instagram. This one's in lowercase. Try and get me on TikTok while you can before the January 19th. King of Hearts 316 2021. Or you can email me at kingofhearts316_09 at outlook.com. And if you want to support me financially, keep me going on doing these lives, I have no problem accepting whatever you can offer. You can hit me up on PayPal me EKB316, Cash App $EKB316, or Venmo EB the Last Outlaw. As always, nothing is obligated, but it's always appreciated. Ladies and gentlemen, this is where we part. This is your home for true crime news without the drama, where your opinions matter where lively debates are encouraged, where your voice is heard, and above all else, justice is served. I love you guys. This is Bethea'S Byte, and it's reloaded. I look forward to coming back on here again next week. Same time, same place. Ernest Bethea, the last outlaw. Thank you all so much for joining me. And until we meet again, you all know what to do. Bite.
Thanks for watching and joining me here at the drama-free true crime destination. Be sure to like, share, subscribe to the channel, and drop me a comment on this video. Also, be sure to follow Bethea'S Byte Reloaded all over social media. This is Bethea'S Byte, and it's reloaded.